You're on Radio 97. Talking Law is the program. We only have a couple of weeks to go before we wrap up for the year. If you have any last minute questions, legal questions at all, then head to radio97.com.au. There's a couple of ways of getting those questions to us. And, Despina will do some very quick last minute research for you and hopefully have it on the air before Christmas. So radio97.com.au.
Thank you, Ano. And you might have heard before the break, we are now talking about this Gold Coast story in regards to a couple who lost their deposit, a $60,000 deposit for their $600,000 home in Burleigh. Now, Despina, it seems like there's a little bit of bad media floating around this particular developer. But yeah, can you give your insight as a lawyer as to what happened, what went wrong here?
Yes, I'd love to do it. And I think the article written by the Gold Coast Bulletin, or I think it was ABC actually, that actually wrote the article, to be honest. But regardless, it was very much one-sided and both views weren't taken. Now, it might have been that the developer didn't want to actually speak to the particular author, and that was, or the journalist that was running the story. But what we want to talk about very much today is how does it work in and off the plan? Because when I read the article, a few things didn't stack up. And being in the off the plan space and being an expert in this area and having advised hundreds, if not thousands, of buyers who buy into off the plan and advising them of their risks and advising them of how it works in relation to having to settle, what happens to your deposit if you don't, making sure everything is you're ready in time. All of these things are very important. But it struck me that if the article is accurate, and if you read the article, it seems to me that these buyers didn't get proper advice. Or if they did, they might have ignored it. And it was very much an article of poor buyers, horrible developer. And I want to sort of twist that around, turn it around and say, well, is it really the case? And I want to really have people listen up to what actually happens. And is it really a developer being horrible? And is it really all the developer's fault? And I don't think it is. Yeah. Okay. And I know in some cases it is not 100% the developer's fault. So what happened here, we'll give a little summary. There was an off-the-plan development at Burleigh that came to fruition that was actually completed and settled. So settlement was called for. This article said that this New Zealand couple who had bought it off the plan, I think 2-3 years ago, obviously locked in a price, was 600,000, which is now quite cheap. You can't really get apartments. Yes, it's very difficult to find that on the Gold Coast. We can all agree as to that. Fast forward, settlement was called for at obviously a particular time. In this particular project at Burleigh, we actually represented buyers. So I can actually talk firsthand at information that was being given to buyers by the developers' representatives along the way in terms of updates. So I can actually attest to that firsthand as to how proactive the developer was in this particular case in advising buyers up front, advising them of updates, advising them of step-by-step guides to settlement, to what to do after you move in and how it all works. Now, that's from the developer's representative, which really they don't have to do, but they've chosen to do that, and they were very proactive. The buyer, on the other hand, is represented by someone else, a lawyer, you would hope. In this case, I don't know if the lawyer was actually someone who knew what they were doing. I don't know, because the article talked about, well, the lawyer told the buyers, okay, if you can't settle on the settlement date, we'll just ask for an extension and it'll probably be granted. And the developer will just charge you default interest and penalties and costs and all sorts of things. Now, if buyers are told that by anybody when they enter into an off the plan, or indeed told in the lead up to settlement, that is absolutely inaccurate. It's absolutely wrong. What we tell buyers from the beginning all the way through into the lead up to settlement at the end is, you sign an off the plan contract. Like any contract, you commit to buying and you commit to settling. Time is of the essence in Queensland. You have to settle on the settlement date. You are not just given an extension because you asked for it. You have signed a contract. You're obligated to settle. The developer has done his or her bit. You are now required to do your bit. You have to settle. There's a settlement date called for, and you need to know when it is. You need to be prepared. If you are not prepared, you will lose your deposit. We tell buyers this up front, say 4 years in advance of their anticipated settlement date. And we remind them 3 months, at least 4 months out of the anticipated completion date.
Get
Hey,
ready,
reminder.
get ready. Yep.
That's right. Remember the conversation we had 2-3 years ago?
Yeah.
We're having it again now. If you can't settle on the settlement date when it's called for, and we don't know when that is, then you will have your contract terminated and you will lose your deposit. It's not may, it's will. And we don't allow the buyer to have any scope or any thought that, to be a bit blasé and a bit casual and, it doesn't matter, he'll just give me an extension because I'm asking for it. I'm a good guy. I'm genuine. I really want this. Well, if you really want to settle and you want your dream apartment, as this New Zealand couple said, that they were waiting to relocate to the Gold Coast, well, you better get everything in order. You better get all your ducks lined up in a row. Yeah. You better know about that. You need to get proper advice. You need to talk to your bank at least 2-3 months out. Make sure you give them everything ready to go, because when settlement is called for, you must settle. There is no ifs or buts about not being able to settle.
So in this case, this couple from New Zealand, they asked for an extension of a couple of days?
Well, the article said initially 5 days, and then they asked again for 3 days and then 2 days, and they were knocked back at each time, apparently, if that's accurate.
Yeah. And then that's obviously how they ended up losing the deposit, because the developer said, nope, we need to settle. And if you don't, you're breaking contract. We'll take the money.
Exactly. Exactly. And remember, you've signed a contract. You're committed to settle on the settlement date. It's a contractual obligation. It's a contractual obligation to settle. You can't be casual and go, something's happened. My bank's not ready. I need an extra couple of days. And yes, it'd be very unfortunate if your bank or the broker organizing your funding didn't have everything ready in time. And that is also about who do you have representing you, because we also educate brokers and educate funders early on. If you're funding someone on off the plan, developer will terminate this and they'll lose. We actually put it on record, so we might be able to cover the buyer if the bank or the broker does the wrong thing in terms of negligence, because we put it on record to say, you have to do everything to make sure that we settle. Otherwise, this buyer will lose their significant deposit and we're going to come after you if you are at fault.
Yeah.
If you have been negligent or you've omitted to do something which causes a delay. So that's really important. And that could be something outside the buyer's control. So we very much hone in on banks, funders, brokers early on to make sure that they're also informed, because brokers and funders can also be a bit blasé about the process.
Yeah. You've said before that obviously this comes down to advice, because the laws, the rules are different in Queensland to certainly to New South Wales and probably most of the rest of Australia as well. So does it really come down to if someone gives you the wrong advice, like you're literally looking down the barrel of potentially losing, well, like this couple did, 60 grand. It could be more if you've got $1 million purchase or even more still. So we're talking a very large amount of money that's hanging on particular advice from someone who perhaps should know better.
Well, yes. I mean, I don't think it could be, I shouldn't say that. Depends on the person giving advice, whether there was negligence or not. I'm not saying that. I'm saying sometimes that the people who represent these buyers are not experts in off-the-plan spaces, and they believe that an extension would just be forthcoming from a developer. But I've been in this space for 20 years, and I can tell you that developers rarely give an extension. They are not there to support the buyers from the point of view of giving extensions galore. And once you give an extension, the word gets out, and then you can have all the buyers asking for extensions. And then if one buyer gets an extension and the other buyers don't, then there's a chaos. There's all sorts of things that could happen. There could be backlash at the developer. There could be all sorts of nasty stuff. So the developer makes a rule across the board: there are no extensions. When settlement's coming up, we give you that notice. You should get advice from someone who knows what they're doing, and you need to know and get all your ducks lined up in a row well before in advance. And we will not be extending under any circumstances. So very much it's about being aware, having that right advice, understanding your risks and obligations on and off the plan from day one. And then everything will be fine, hopefully. And then be able to settle.
Yes. We all live happily ever after. Yep.
Exactly.
Oh, well, thank you so much again for your time this morning, Despina. Like Wayno said, if you do want to get a question in before we go on holidays, which is when for Priala Legal, what data are you guys clocking off?
We actually close the Friday, the 22nd is our last working day. That's our last working day. And we're going to be very busy tidying up files and all sorts of things. And then we're not back until the 8th of January. I'm trying to get another week to myself if I can.
You'll have to talk to the boss about that. Yeah.
Yes, exactly. Yeah, I don't know how I'll go with that.
Mhm.
But the staff are back on the 8th. So the
Wonderful.
office is officially open then. Yeah.
Great. And any questions we don't get to this year, we can always answer in the new year. So if anyone does want to get in touch, Despina, where can they go?
Yes, they can email info@prialalegal.com.au, or they can reach out onto the Facebook community page for Breakfast Radio 97, or they can phone the office 55 291 294.
Perfect. And we'll talk next week.
See you then.
Great. See you then, guys.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.